We'll stay on the bench, but we're in recess so that the next case can come on up, and that's 23-2160. I believe it's Andriotis versus State, and I'm sure somebody can correct me on the pronunciation.
You said it right.
Okay, good, thank you. All right, same instructions as before. You get 20 minutes per side. If you want something other than 5 minutes for rebuttal on the appellant side, let me know and I'll change that. And with that, we're ready for case 23-2160, Andriotis versus State.
Good morning, Your Honors. 5 minutes for rebuttal will be sufficient. May it please the court, my name is Eric Cerise. I'm here on behalf of Mr. Gregory Andriotis, the appellant in this case. Your Honors, we think this court should reverse Mr. Andriotis' judgment and sentence for the issues that we raised in our initial and reply briefs. Although for purposes of oral argument today, I'd like to focus the majority of my time on issues 2, 3, and 5 as labeled in the briefs. That is, the trial court's evidentiary rulings as it relates to the time frame of Mr. Andriotis' cell phone use, the admissibility of the deposition statements of our client, and the trial judge's decision on the motion for judgment of acquittal. I'd actually like to start with the judgment of acquittal issue. As this court is aware, in vehicular homicide cases, whether the evidence supports the recklessness factor is a fact-intensive case-by-case inquiry, and it considers the totality of the circumstances as it relates to the defendant's driving conduct.
So for conduct to be considered reckless, it has to be willful and wanton and in disregard for safety of others, right?
Yes, that's the standard. That's what the jury was instructed on.
So why would not minutes, and I don't know why the microphones are so hot, they're ringing fairly substantially. Why would not multiple minutes of engaging with technology on your cell phone, which is effectively a computer, downloading programs potentially or the like, why under these facts would that not be willful and wanton?
Well, Judge, I think the bulk of the case, two responses to that really. The bulk of the cases in this field suggest that it's about the maneuvering of the vehicle in such a wanton and reckless manner. It's things like driving a grossly excessive speed, things like maneuvering through lanes, weaving in and out of traffic.
But it's not only that.
It's not only that. I would agree with that.
I mean, technology advancements perhaps can open up new ways of being willful and wanton in disregard to the safety of others, such as being on your phone for that duration of time with that distance between you and stop traffic.
Of course, and I think, like I started with, I think, every case is going to be a fact-intensive inquiry. But in this case, and I think Your Honor actually makes a point that drives this recklessness inquiry is the timing with which the jury received evidence of that cell phone use. So as the testimony bore out and the expert cell phone extraction testimony bore out at trial, Mr. Andriotis' most egregious cell phone use was some 10 to 12 minutes prior to the time of the accident. And in fact, the judge below, in his ruling on the judgment of acquittal, made a couple comments that, in our view, suggest that the The appropriate inquiry as to whether Mr. Andriotis was driving recklessly was immediately before the accident, or that was short minutes of time before the accident is what's really the inquiry. And the judge made these comments during the JOA that suggested that the state didn't really have much evidence in terms of that particular question.
Counsel, let me ask you this. If he had driven with a blindfold on for the last 15 seconds before he smashed into the other car at 70 miles an hour, you would agree that that's reckless driving, wouldn't you?
I think I would have to, Judge, yes. I think the
When you're not looking at all where you're going, whether you're looking, I don't care if you're looking at a computer screen, a telephone screen, you're petting your dog in the back, when you drive for 15 seconds at, I think the EDR said 79 5 seconds before, so we use 79 seconds. When you drive that length of time without looking where you're going at that speed, is that reckless driving?
Well, I think under your specific hypothetical of intentionally placing a blindfold on you while you're driving.
I'm talking about just being distracted, just not looking where you're going for, what was it, 15 seconds, I think the calculation came out, something like that?
Anywhere from 14 to 16, yeah. And I think
15 works.
Yes.
Okay.
No, I don't think that automatically amounts to recklessness, Judge. I think there would need to be.
How is that not reckless to drive at that speed, assuming you are looking where you're going with no intention of trying to maneuver or stop?
Well, I think the example that I would give is a driver who was simply daydreaming for that amount of time. I think that kind of fits with what the court is asking. And in that instance, I don't think that's the intentional conduct that these.
We don't have daydreaming here.
We don't.
We have purposeful distraction, whatever it is, whether it's telephone, whether it's a phone call, whatever else, whatever it was that he purposefully did, he was not paying attention to where he was going. If he had been, this wreck wouldn't have happened the way it did. It may have still happened, but it certainly wouldn't have happened with this violence.
Sure. And I think at the end of the day, that conduct amounts to carelessness or just plain inattentiveness. It doesn't amount to the recklessness standard, which is a higher standard to meet. And certainly Mr. Andriotis will pay for his conduct in the civil context. We don't think that his conduct amounts to criminal conduct. And
does the statute contemplate willful or wanton conduct? You agree with that, right?
I believe so, yes.
It's willful or wanton.
Yes.
So then perhaps intentionality is not required, is it? Intentionality of conduct. I mean, one could argue if an individual intentionally drove his car 79 miles an hour into a stopped car, one could make an argument for second-degree murder. Wanton contemplates, and if I'm looking at case law, wanton contemplates that which is done with a conscious and intentional indifference to consequences.
Right.
So negligence probably doesn't constitute wanton conduct. What we would call general routine negligence. I hate to use that phrase. Nothing routine whatsoever about this case, not even remotely. But a conscious indifference, does that require intentionality? I mean, certainly your client didn't intend to do this, one would assume.
No, I think that's a fair parse of the jury instructions and what the jury is instructed on in vehicular homicide cases.
Which is based on Florida statutes.
Correct.
Okay.
Correct. But on the topic of supplemental authority, we actually filed some supplemental authority cases in the civil context that we think this court can borrow some of those principles on. So a recent case from the 4th DCA, I believe, the Creech case, that was decided after briefing in this case. And in that case, the defendant driver was texting and driving while he got in an accident, and the plaintiff moved for punitive damages. And in the punitive damages world, in relation to negligence, that standard kind of tracks with the recklessness standard. So in Creech, they say, in order for you to establish that you're entitled to punitive damages based on the defendant driver's conduct of texting while driving, you have to show either intentional misconduct, which I understand the judge, Your Honor, thinks is not exclusive, that it can also be that wanton and intentional or disregard for the consequences, but that's covered as well in the civil context as it relates to punitive damages. It says another way to get that is gross negligence, which means that the defendant's conduct was so reckless and wanting in care that it constituted a conscious disregard or indifference to the life, safety, and property of others. And so in the Creech case, despite there being evidence of the defendant driver texting while he got into this accident, the court there rejected any claim for punitive damages, essentially saying that the mere use of a cell phone while driving does not automatically provide a basis for the plaintiff to seek punitive damages.
In
And
Creech,
that's
was there evidence in Creech that the driver had failed to look forward, look at traffic, look at his surroundings for the 15 seconds before that collision?
I believe so. I believe there was evidence of
That length of time?
no. That was my caveat. Was I don't think the court describes in terms of the time frame. I think that is a unique fact in this case. But I want to talk about the extent of the cell phone use because I think that's important. I think there is an impression that the use of Microsoft Excel, which as professionals we know is a rather complex tool on our desktops, that automatically means that he was so extensively using his cell phone that he was just entirely reckless. But I think a review of the expert's testimony, particularly the cross-examination, which begins at page 1208 of the trial transcript, the cell phone expert makes a lot of concessions and makes a lot of acknowledgments in terms of what his assessment of that cell phone evidence actually tells us about whether Mr. Andriotis, or the extent of his device interaction was the terminology, which my understanding of this field is a tap to the phone. But what the expert did not take into consideration, or what his assessment did not consider, were several things. The concept of autofill or self-population. So instead of typing out your full email address or your password, your phone has the technology to remember those things, and it's simply just one tap for those things to auto-populate. The same thing with voice command and Bluetooth. The state places a lot of emphasis on this idea that Mr. Andriotis answered phone calls while he was driving, but I would posit that that doesn't amount to recklessness whatsoever. Every day, I think drivers are answering phone calls as they're driving, especially with the technology that we have today with the hands-free Bluetooth technology. So I don't think that really helps the state in terms of the recklessness inquiry. It's really about whether his use of the Excel and his download, his search, and use of the Excel amounts to that wanton and willful standard that's required for this court to sustain a VHOM conviction. So I think when you look at the cell phone experts' acknowledgments that a lot of these things that were equipped in Mr. Andriotis' phone, were equipped in his car, it kind of lessens the impact of his use of the cell phone. And so then it becomes a question of, was his tapping his cell phone for the span of approximately 10 to 12 minutes prior to the accident, as well as going only 79 miles per hour in a 70 on the highway, which the courts consider the context or the surroundings of the driving conduct as being important to the recklessness inquiry, whether that amounts to that high standard of recklessness. I think the math actually that the defense lawyer came up with based on the calculations of the Florida Highway Patrol officers was that Mr. Andriotis likely tapped his phone once every 40 seconds. That, I think, on its face does not come off as what you would expect one to be doing on Microsoft Excel, which inherently does have some sort of appeal of being a complex application.
Does this line of argument as to minimizing the degree of engagement with the technology on the cell phone ask us to equally minimize, if not disregard, the sheer context of the facts surrounding the accident and the amount of time available to stop prior to impact? No, and I understand where you're going with the argument about, oh, he could have used Bluetooth, or oh, there was autofill, or oh, it's just tapping a couple of things. But certainly in determining willful or wanton conduct in the specific context, fact-intensive context of this particular case, we can also view what's going on in the broader sense of how much time did he have, how much distance, how much line of sight obstruction, if any, all those sorts of things, and a box that says there was no engagement of the brake prior to impact.
I think those facts are different from the cell phone usage facts, because I think there's more ambiguity with the cell phone usage facts as opposed to the other facts that Your Honor mentions, because those are facts that are
But they could relate to each other, could they not?
Certainly could, but those facts are, in a sense, set in stone. There's no real dispute about his line of visibility. There's no real dispute about the timing with which he had to react. I think there is a dispute as to the extent of his cell phone evidence.
Did somebody offer some other reason that he wasn't paying attention? I'm not trying to put a burden on you guys to prove anything. I'm just asking if I missed something.
My recollection of the record and the trial transcript, I don't think there was an affirmative explanation for the
I'm not saying you had to. I just wanted to make sure I didn't miss it.
Sure. No, then that's a fair question. But no, Judge, my recollection is I don't think there was an affirmative point put forward. But nonetheless, I think when you look at the ruling on JOA, when the judge makes the ruling, it begins at 1247 of the trial transcript. The judge himself states that the state presented minimal evidence on the driving pattern and conduct of the defendant just prior to the accident. So the judge is even recognizing that, there's a lot of evidence of what Mr. Andriotis was doing some miles before the accident or 10 to 12 minutes before the accident, but right there before the accident, the state doesn't have much. So I think that's an acknowledgement that this is actually a closer case than it may appear or than the state might be arguing. But what might have pushed the jury over the line to find that Mr. Andriotis drove reckless was some of the improper evidence that was admitted at his trial that lengthened the time frame that was ever so important in this case for the jury to consider additional conduct of his driving patterns. That being, namely, that the judge erred in expanding the time frame of his cell phone use, and that the judge erred in allowing Mr. Andriotis' deposition statements to be testified to by the civil lawyer who took the deposition. I'll take those in turn. So, as I'm sure the court is aware, the original timeline that was set by the trial judge in this case was from 3:28 p.m. moving forward. The crash was estimated to have occurred sometime around 3:36 p.m. So that would be an 8-minute time gap to assess Mr. Andriotis' driving pattern. We think that time frame is what should have stuck. Having opened the time frame back 2 minutes to 3:26, right, to 3:26, the argument was that allows for the judge or the jury to consider that Mr. Andriotis searched for and downloaded the XL document or the application. But there's two really important points for this particular issue. The first is that the cell phone expert was able to opine as to Mr. Andriotis' cell phone use without those additional 2 minutes. His conclusions, which were at the hearing on the motion to reconsider that the state filed, was that Mr. Andriotis was using his cell phone and particularly was engaging with Microsoft Excel without even having to describe that he had previously searched for and downloaded it. So it really doesn't add anything to the appropriate time frame of the recklessness inquiry. It really just has the jury considering evidence that's too far remote in time and in distance from the actual accident. And the last thing I'll say before I leave the remainder of my time for rebuttal is essentially it's the same argument with the deposition statements, and arguably even more egregious, because the deposition statements have absolutely no set time frame. They're not grounded at all in when these things occurred. So the deposition statements specifically are that Mr. Andriotis was surfing the web or navigating to a website and that he was looking down at his phone. But there's absolutely no time frame on that. This is despite the efforts that the trial judge made to create a time frame, because the judge frankly recognized that that's important in these cases. And so in light of that impermissible evidence that the jury was allowed to consider, we think that Mr. Andriotis is at a minimum entitled to a new trial, but we do urge this court to find that as a matter of law, his conduct doesn't rise to the level of recklessness such that this court should reverse his judgments and convictions. With that, I'll save the remainder of my time for rebuttal.
Right.
Good morning, Your Honors.
Morning.
May it please the court, my name is Dan Caldwell with the Attorney General's Office. I represent the state of Florida in this matter. This was a very large trial transcript, large records. Appellant has raised lots of issues. I don't have any points I wish to make in addition to the points Your Honor's made, but I would do my utmost to answer any questions the court may have for me, since there are a lot of issues.
Why don't you explain to us why it was appropriate for the trial judge to back up the admissibility of what he was doing back to the 26-minute point?
When the first motion in limine was filed, the state did not yet have Dr. Antal's report, so the court did not at first have all the facts. And also remember, the court really only expanded it by, I believe, it was originally from 328 to 336. The court moved it back to 326, and I wanted to say 51 seconds.
Correct.
So it was actually only about a minute, and that he could testify regarding the cell phone call with his wife, which I think occurred around 321. So these are inextricably intertwined. As the court, I don't want to presume to know what Your Honors are thinking, but it appeared to me that the court seems to, or I'll simply argue, that the driving pattern and all the evidence was the cell phone extraction evidence was inextricably intertwined. This isn't a situation of someone driving and just glancing at their cell phone to get a text. This gave the jury, the state needed this evidence to paint the full picture, to say, okay, it had just rained, but it was clear visibility, a 1,900-foot stretch of highway. Every other car on the road saw that traffic was stopped. This car did not. This car plowed into the back of another vehicle, made no evasive maneuvers, according to the EDR box, did not brake. So what would explain this lack of attention? Well, because we had an individual who was engaged with a phone call with his wife, with an individual, Casey Casado, I believe was his supervisor, that he had downloaded an Excel spreadsheet. He was having difficulty opening it, so we tried to open it with an app called Polaris. That didn't work, so then he had to download Microsoft Excel. In order to use that, he had to log into Microsoft Excel. He also navigated to Capital One, the Capital One site, in order to pay a bill. So we have an individual who was also using first the Waze app, which he then closes down and uses the Google app, the Google Maps app. So we have an individual who's engaged in all sorts of multitasking while driving a vehicle in excess of 79 miles per hour. So of course the court had to, or properly expanded this so that the state could say, ladies and gentlemen of the jury, here's why this cell phone was receiving so much data until 3:35 when the collision occurred. And that is why, Your Honor.
All right. How about the deposition excerpts from the civil trial?
Yes, Your Honor. I think those are clearly admissible, most clearly under an admission against interest. Appellant himself testified in the deposition that he was navigating to a website. As the court pointed out, he was a bit artful with his words. When he was asked, did you surf the web? And the attorney asked him, he said 3 times because he wanted to make sure he heard the answer correctly. Well, whether you're surfing the web or whether you're navigating to a specific website, you're still using the web. And clearly the evidence, the probative value was outweighed by any prejudicial effect. I notice frequently the argument that will come from appellants in prejudice versus probative. They'll say, this is really damaging evidence. Well, of course, it's in essence a confession. It says, I was using a computer while driving. But of course, that's probative. The only way it would be prejudicial would be if it invited the jury to make their decision on an impermissible factor, such as emotion or facts not in evidence. This would clearly assist the jury in deciding whether or not he really was distracted. And it is true it's a bit unclear as to when that time period was, but that would leave that issue to the fact finder as well. Did he mean he was looking at his phone and he was engaging with it 10 minutes before the wreck or up to the wreck? And that question was answered 3 times.
Does my colleagues have any other questions? All right, thank you very much.
Very well. Then the state would ask the court to affirm the judgment sentence below. Thank you for your time.
Thank you.
May it please the court, just a few points on rebuttal. The first is that in terms of whether this evidence of his cell phone use some 10 to 12 minutes prior to the accident is inextricably intertwined, it's really just a way of determining whether this evidence was relevant. And conduct that occurs 10 to 12 minutes before the actual accident, and presumably at least a mile or a mile and a half prior to the accident, is just simply not relevant to the recklessness standard. We actually filed supplemental authority on that issue. It's the Russ case. It's a civil case, but I think that there's a lot of overlap in this analysis where the trial court in the Russ case excluded testimony that the defendant driver was driving in an erratic manner some 1.5 miles away from where the accident occurred, and it says, or 3 or 4 minutes prior to the accident. The Russ decision affirmed the decision of the trial court to exclude that evidence as being too far remote in time and distance from the accident, so I just don't think it's relevant. I think the use of the evidence of Mr. Andriotis' cell phone use was undoubtedly a feature in this case, and the state's case hinged on that. It was referenced something of 8 times during closing argument that he searched and downloaded his phone. It's important again to note that the expert was able to opine that Mr. Andriotis was using Microsoft Excel under that initial time frame, so it was unnecessary to go back to those 2 minutes. Someone can certainly be reckless at mile marker 1, get in a car accident at mile marker 10, and not be guilty of vehicular homicide because that reckless driving conduct has gone away. And as far as the deposition statements, the last point I'll make, we don't dispute that the deposition statements in themselves could be admissible as a hearsay exception. We understand that. Our position is that the judge made a mistake by not properly excluding them under 90.403. As this court is aware, evidence can be admissible but still and relevant, but still inadmissible based on its overtly prejudicial value. And what we have here are statements that Mr. Andriotis was navigating to a website and looking down at his phone without any effort to ground that in the very important timeline in this case. The judge made painstaking efforts to establish a time frame. And instead, he eviscerated that time frame when he allowed these deposition statements to come in. And the last point I'll make is that the lawyer below specifically argued that the deposition statements tended to suggest that Mr. Andriotis was using his phone prior to when he downloaded Excel, and that was the time frame that was established. So we'd ask this court to reverse. Thank you.
All right, thank you very much. We will be in recess until our 11 o'clock, so thank you.